1968 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ30 Chief Court Criminal Revision before ဦးစိန်သိန်း Judge ဦးထွန်းအောင်သာ Applicant versus the Union of Burma Respondent ဤစီရင်ထုံး audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေတော်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် The Unlawful Association Act Section 17(1) exchanging the boots for the lost gain, whether the act can be said to have contributed for the purpose of assisting an unlawful association. Questions of mens rea, whether a conviction under Section 17(1) of the Unlawful Associations Act is sustainable in the absence of mens rea. The appellant's gain was robbed and the same was finally recovered only on payment of 10 pairs of boots to the communist insurgents by way of ransom. Hell, even if the act of the applicant in supplying the boots falls within the ambit of the term exchange as defined in Section 118 of the Transfer of Property Act, he can still be said to have contributed the articles for the purpose of an unlawful association, within the meaning of Section 17(1) of the Unlawful Associations Act, as his act clearly amounted to the giving for the common purpose of the use by the members of the association. Hell further, so far as statutory offences are concerned, words of statute are given effect to as they stand without bringing in the extraneous mens rea doctrine for the purposes of determining the guilt of the offender, and the dictum applies to a conviction under Section 17(1) of the Unlawful Association Act. Dr. Gordon S. Seagrave versus the Union of Burma, 1952, BLR, SC, page 44. Ravla Hari Prasad Rao versus the State, AIR, 1951, SCR, page 204, distinguished. The Union of Burma versus AUNG, 1957, BLR, HC, page 58. The Union of Burma versus AUNG, Criminal Reference Number 16 of 1956 of the High Court. Ganesh Narayan versus the Union of Burma, 1959, BLR, HC, page 6, referred to. U Myin So for the applicant, U Mya Sein for the respondent, U Sein Tin Judge. The undisputed facts of the case are that the applicant Utung Aungta, 33, whilst on duty as agricultural assistant in Burma district, had his gain robbed and that the same was finally recovered only on payment of 10 pairs of boots to the communist insurgents by way of ransom. Two questions have been posed before me by U Myin So, Land Counsel for the applicant, viz. A. Whether in exchanging the boots for the gain, which the applicant had lost, he could be said to have contributed the boots for the purpose of assisting an unlawful association, and B. Whether in absence of mens rea, he could be convicted of the offense under Section 17(1) of the Unlawful Associations Act. The first question does not present much difficulty, although U Myin So had tried to draw a distinction between the words contribution and exchange. U Myin So will have the court hold that the act of the applicant amounted to exchange as defined in Section 118 of the Transfer of Property Act, and as such, he could not be said to have contributed the said articles. The word contribute, according to U Myin So, contemplates payment of something gratuitously without any prospect of getting back something in exchange for it. But the word contribute, as used in Section 17, has no special legal connotation. It is not defined in the Act. In ordinary parlance, a person is said to contribute a thing when he paid or furnished the thing to others for a common purpose. In the Oxford Dictionary, the meaning of the word contribute is equate with that of pay or furnish. And in Chambers' 20th century dictionary, the meaning is given as to give along with others, to give for a common purpose. Therefore, even if the act of the applicant in supplying the goods falls within the ambit of the term exchange as defined in Section 118 of the Transfer of Property Act, he can still be said to have contributed the articles for the purpose of an unlawful association within the meaning of Section 17(1) of the Unlawful Associations Act, as his act clearly amounted to the giving of goods for the common purpose of use by the members of the association. The question regarding mens rea is, however, not free from difficulty in view of the observations made by the late Supreme Court in Dr. Gordon S. Seagrave versus the Union of Burma, 1952, BLR SE, page 44, as follows. It is one of the principles of the English law, as well as that of our law, that a crime is not committed if the mind of the person doing the act is innocent. The same view was adopted by the Supreme Court of India in Ravla Hari Prasad Rao versus the State, AIR 1951, SCR, page 204. The head note of which reads, unless the statute clearly or by implication rules out mens rea as a constituent part of a crime, a person should not be found guilty of offense against the criminal law unless he has got a guilty mind. Whether the person has a guilty mind or not in doing an act prohibited by law must be judged by the surrounding circumstances of each case. The above observations naturally lead to the conclusion that in determining the guilt of the accused person for any of our statutory offense apart from the definition of the offense as crystallized in the statute itself, such a thing as mens rea exists without the proof of the existence of which, in the mind of the accused, no criminal liability arises. With due respect, these observations are, to my mind, obiter dictum, inasmuch as the real question before the late Supreme Court then was whether the offense of aiding and abetting treason, punishable under Section 4(1) of the High Treason Act, was committed by the accused under threat or compulsion. The statutory defenses available to the accused under Section 94 of the Penal Code, in respect of the accused's mental attitude in the commission of the offense. A careful perusal of the points made in that case clearly shows that the appellant, Dr. Gordon S. Seagrave, was held to have committed no offense as the acts done by him were performed in subjection to the power of others, viz., the current insurgents who were proved to be brutal persons. It can therefore be seen that it was not so much on account of the absence of mens rea, but due to the presence of a reasonable apprehension of instant death that the appellant earned his acquittal. In a more recent case of the Union of Burma versus AUNG, 1957, PLR HC, page 58. It was held that the questions of mens rea is irrelevant for purposes of determining criminal liability of the accused, summed up under Section 4(1)(d)(4)(2) of the Suppression of Corruption Act. The land judge who decided the case made reference to the case of the Union of Burma versus AUNG, Criminal Reference Number 16 of 1956 of the High Court, a bench case which, though not reported, has been embodied in the General Letter Number 17 of 1956 issued to all the courts for guidance, in which it was held that so far as statutory offences are concerned, words of statute are given effect to as they stand without bringing in the extraneous mens rea doctrine for the purpose of determining the guilt of the offender, and that if the definition does not include the requirement of a particular mental condition, we must give effect to it as it stands, holding the omission to be deliberate. The above dictum was endorsed by the land judge in spite of the ruling in Dr. Gordon S. Seagrave's case, supra, to which his attention was invited. Then again, in the case of Ganesh Narayan versus the Union of Burma, 1959, PLR HC, page 6, which was a case under Section 9(2) of the Foreign Exchange Regulation Act. It was ruled that so far as statutory offences are concerned, words of statutes must be given effect to as they stand without bringing in the extraneous mens rea doctrine for purpose of determining the guilt of the offender. Mian-Soo, Land Counsel for the applicant, has also made a reference to an unreported case of the late High Court in Criminal Revision Number 25B of 1956. In that case, U Tang Sein judge, after referring to Dr. Gordon S. Seagrave's case cited above, held that the act of the accused in giving a sum of Jet 600 to the insurgent for the purpose of ransom in respect of his elephants, which were captured by the communist rebels, did not amount to contributing any sum for the purpose of assisting the Burma Communist Party. It was therefore ruled that as there was no mens rea on the part of the accused, when he paid the sum of Jet 600, he could not be convicted of the offense charged against him. With respect, I cannot persuade myself to hold that just because the sum of Jet 600 was paid for the object of getting back his animals, his act could not be said to have amounted to giving contribution to the Burma Communist Party. No doubt he was actuated by the desire to get back his elephants, but it is difficult to resist the conclusion that he was fully alive to the facts that the money would ultimately be made available for use by the members of the unlawful association. In any case, the facts and circumstances obtaining in that case are somewhat different from the present case before me, inasmuch as the pledge of the accused in that case was such that, to use the words of the land judge, it was impossible for him to enlist the support of the police, as there was no police station in the area, and unless the ransom was paid, there was every likelihood of Luso's seizing the remaining elephants and mahouts. In the instant case, before me, the circumstances do not indicate that there was no alternative except to supply boots to the rebels for the purpose of getting back the firearm. In any event, I feel that in considering such an important point of law, I need more than what I respectfully consider is a mere ipse dixit, even of the eminent judge who decided that case, to satisfy me that just because the boots were given with the sole object on the part of the giver to get back his property, the supply did not amount to contributing the articles for the purpose of an unlawful association, even in spite of his knowledge that they will be utilized by the members of such association. Strictly speaking, the absence of mens rea consists in an honest and reasonable belief entertained by the accused of the existence of facts which, if true, will make the act charged against him innocent. In other words, the doctrine of mens rea applied whenever the facts which are present to the prisoner's mind and which he has reasonable grounds to believe and does believe to be the facts would, if true, make him act no criminal offense at all. Here, it is not the case of the applicant that he was not aware that the boots were to be given to the communist insurgent. On the other hand, there is evidence to prove that he did hand over the boots, knowing fully well that they were to be utilized by the insurgents. No doubt, he may have acted with the best of motives, which may even be said to be laudable, inasmuch as he had acted in the realization that a firearm, if put to effective use by the insurgents who were waging war against the state, will be more formidable than a few pairs of boots. But this motive, apart from being an irrelevant element in considering in the guilt of the accused, is not by itself a proof of the absence of mens rea. In the circumstances, I am unable to hold that the trial court went wrong in registering a conviction against the applicant under Section 17(1) of the Unlawful Association Act. This application is accordingly dismissed,